Today, we're going to discuss contractual extensions and how to limit your business and professional risk. As you all know, design firms typically obtain insurance policies that provide coverage for various types of damages and liabilities that you may have. And insurance is certainly one form of risk transfer mechanism. However, there are many other provisions in the contract that can have a significant financial impact during the project, but are not strictly related to your professional services, nor are they directly addressed by the coverage of your professional liability policy. And we will be discussing some of those issues in this webinar. So the goal is to briefly go over what the professional liability policy covers, what your contractual obligations mean, and then we will talk about those areas in your contract that may well go beyond what is covered by your professional liability policy and how you as a design firm can prudently manage those risks. So first things first, let's go over some fairly basic concepts so that we can lay the groundwork for what we're discussing today. Let's review exactly how liability is determined in the U.S. legal system. And in the U.S. legal system, generally speaking, courts would look to see what your duty is. If you fail to breach, failed in that duty, in other words, you failed to meet that duty that's been prescribed, and we'll talk about a series of the law in a second, and that breach causes damages, then you are deemed to be at fault and responsible for those damages that are suffered. So the thing we need to understand as a basic concept is there are two areas of the law as a design firm that you need to be aware of. The first is tort law, and it provides the framework for professional liability responsibility. It provides the negligence standard, which is based on the standard of care. As a design professional, whether you be an architect, engineer, surveyor, landscape architect, or whatever the case may be, you're expected to perform services in the same way that another professional would have. And that's generally defined as the standard of care. If you fail to meet that standard, if you breach that duty, then, and that causes damages to somebody, you're going to be held responsible for that because that is what the law expects of you in the U.S. legal system. So that's the standard to which your professional liability policy is written. That's the standard to which the insurance companies certainly feel like they have a handle on what you all are doing and can price that exposure and provide you with a professional liability policy to provide coverage for that. But as design firms, as you all know, you enter into relationships with your clients, and those are based on contract law. So as you enter into your agreements, you are free to assume obligations. This is between you and your client with whom you have an agreement. Generally speaking, design professionals such as yourself are providing services to your clients, and the agreement is that you promise to provide them with services, and the client promises to pay you for those services. So you are exchanging promises, promises to perform, promises to pay, and that is the bargain for exchange that you all are entering into. And if all of the elements are met, that is essentially private law that the courts will enforce between you and your client, assuming that what you promise each other is legal and exchanged for legally, and both parties can enter into an agreement that is going to be enforceable in a court of law. Now, as you all know, though, by contract, you can agree to perform in a manner that exceeds your normal legal liability. And as we've talked about in other programs, if by contract you say that I will perform to a higher standard or provide them with a warranty or a guarantee, that is going to be enforceable between you and your client. So to that end, having laid off that framework, there are some areas that we will be talking about specifically that expose you to potential harm, to potential liabilities, that may well go beyond your professional liability, or you can somehow manage between you and your client. And that's the areas of the contract that we're talking about. In prior programs, we've talked about standard of care, indemnity obligations, and so on. This program is designed to cover those areas that may go beyond that aren't necessarily covered by your professional liability policy, but may impose significant risk to you and how you can manage that. So your contract provisions generally govern your relationship between you and your client. And from a risk management standpoint, you certainly need to know exactly what is in your contract. It spells out the scope, responsibilities that you have, what your time obligations are, and what that compensation element that the client is supposed to provide to you, because that's part of the bargain for exchange. It sets out the relationships and communication protocols between you and your client. You need to be able to say who's responsible for specific services, if you need to rely on information provided to you by the owner or by the owner's other consultants. That needs to be spelled out. But there's also a document that recognizes that there is risk and allocates that risk accordingly. And that is what we'll be talking about specifically today. It's that risk recognition, whether it be dispute resolution procedures, risk management procedures, or business concerns that need to be addressed clearly in your contract and accounted for, so that you have that document of mutual understanding between two parties. Now, as I alluded to earlier, between you and your client, it is your agreement that will govern the terms of your relationship. So if indeed there is a dispute between you and your client, the first place that a court would look at is to see what you all agreed to in your contract, to see what you promised each other, to determine whether one party failed to perform or not. So that's how important these contractual provisions are. So as a firm, you need to be able to say, what is your risk philosophy? Are you looking to take on projects that are as close as possible to the coverage of your professional liability policy? Is that where you're most comfortable? Or are there circumstances under which you're willing to take on more, knowing that it's a business risk, and account for it by maybe charging more or having other risk management procedures in place to help account for the extra exposure? So those are the things that you need to realize as a firm to be able to manage your risk. We review contracts, and oftentimes we can provide feedback on what the scope of your coverage is under the professional liability policy. But at the end of the day, as you negotiate with your client, it is up to the firm to decide exactly what it is that they're comfortable with. The client may well agree to negotiate on some parts and not on others. There may be some business risks that are involved that you need to decide on. So as a firm, you need to decide what is your risk philosophy. What do these provisions that the client isn't necessarily willing to negotiate on mean, and how do I account for that? What am I comfortable with? And this is an effort to educate you along those lines. As you all know, negotiating contracts is a fundamental part of risk management between you and your client. And you need to know under what circumstances do you look to make sure you have protective elements in your contract. Under what circumstances do you agree to take on more exposure? All of that really depends, as I said, on the risk philosophy that you have. And then finally, you really have to evaluate the potential advantages and disadvantages of these provisions for each project, depending on the characteristics of your scope, the client, and your experience in that subject area. That is really individual to your particular expertise and what your comfort level is. So to that end, this program is intended to provide you with some guidance along some of these provisions that may well go beyond your professional liability provision, and then beyond your professional liability policy, so that you will be able to more confidently handle these provisions as you negotiate with your client. So, broadly speaking, the concerns that may well go beyond professional liability insurance policy that we'll talk about today are dispute resolution procedures, including prevailing party and accrual of statute of limitations provisions. These have a significant role in dispute resolution between you and the owner. We'll talk about things like the waivers of consequential damages, a very key element that you need to understand and is often a point of contention between you and your client, whether this is something indeed that is a bargain for exchange in your responsibilities. And then finally, we'll look at some business interests of the client, of your own, that may well impact the amount of responsibility you have and impose significant burdens on you, such as confidentiality provisions and ownership of your instruments of service. So let's talk about some of those dispute resolution provisions. Specifically, we'll talk about prevailing party provisions and what that means, and the accrual of statute of limitations provisions, and we'll explain those, and then provide you with examples of how to approach those types of situations. So, having been an engineer in prior life, it's very common to hear feedback that there's too many attorneys in America, and it's generally thought that when compared to other developed nations, the U.S. certainly is considered to have one of the worst legal systems in the developed world. That's not just people complaining about attorneys, but there's actual data to support that. When compared to other developed countries, the percentage of GDP that is spent resolving disputes in the U.S. is much higher. The number of attorneys in the population versus, when compared to other nations is certainly much higher per capita. So there may well be policy reasons for that go beyond the scope of this seminar. But what we want to be able to address is oftentimes the thinking goes that, hey, if the plaintiff or the person suing you was actually responsible for paying the attorney fees of the defendant if they lost, then the likelihood of suing would be reduced. That the prevailing party provision, if it's included in the contract, would make it less likely that you would be involved in a lawsuit. And so there's such a thing in the U.S. called the American Rule, which says that if you're a party to a lawsuit, you are not able to recover your attorney fees unless it is authorized by statute, and we'll talk about that, or contract. So in the U.S. system, if you are suing somebody, and even if you prevail, you are responsible for paying your own attorney fees, unless there's a statute that you can point to that says, yes, you can recover attorney fees, or there's a contractual provision that says attorney fees are recoverable. Contrasting that with the English rule, if you lose a lawsuit, then the loser of the lawsuit is responsible for the winner's attorney fees. Now, we're not going to resolve this issue of what the litigious environment is of the United States, but certainly for folks who are involved with negotiating with contracts, we often see prevailing party provisions included in the contract. This could be something that the owner wants, or the design firm may well want to insert. And our feedback, essentially, from as far as the professional liability policy is concerned, is that this is a contractually assumed obligation, and if you're held to be responsible for the other party's attorney fees, that could be outside the scope of coverage. So you need to be able to negotiate through that and make a determination as to what you're comfortable with. We said that it has to be authorized by statute or contract, but the reality is few states in the U.S. have statutes that award attorney fees. So you should assume generally that you will be responsible to pay for your own attorney fees. There are some fee-shifting statutes that are out there based on the research that I've done. But generally, unless it's a very specific cause or area of the law, fee-shifting statutes are very uncommon. The area that we do see them in some states are in prompt payment statutes, where if the court determines that payment is due on a construction contract and it was not withheld in good faith or reasonable cause, then attorney fees are awarded per statute as part of the damages. But those are typically between owners, contractors, and subcontractors. So absent a contractual provision, you should assume that all parties are going to be responsible for paying their attorney fees. So what do these prevailing party provisions look like? You need to decide as part of your risk philosophy whether prevailing party clause suits your needs. As I said, the feedback from your professional liability carrier is that this is a contractually assumed obligation. However, there may be cases where you would consider it. All right. The reasons that we often see that are outlined by design firms and their attorneys is that, hey, this type of provision actually discourages lawsuits. Parties are less likely to file a lawsuit if they know that there may be something that's going on, but if they lose it, and if they feel that their claim isn't as strong, and they will be responsible not just for their own attorney fees and the other parties' attorney fees, then maybe this type of provision, this type of contractual provision, discourages the owner from filing a lawsuit against you to begin with. So it discourages lawsuits, it discourages weak cases, and essentially encourages negotiations. It restores you to your original position if you are the prevailing party. That assumes, however, that you are the prevailing party. So you want to be able to see, okay, what are the resources of the parties involved? How does that relate to my willingness to potentially take on responsibility for a prevailing party clause? My advice generally is that if you are considering having a prevailing party provision, it should be a project-by-project determination, looking at whether the client, you would benefit in having a prevailing party provision for that particular client or that particular project. Looking at the case law, in a very general fashion, the prevailing party provision itself is often subject to litigation. As you well know, there's attorneys who will litigate whether indeed the prevailing party provision should be enforced. Generally speaking, obviously, the prevailing party clause should be clear and specific. If the clause does not sufficiently put a party on notice that it is an attorney's fee provision, it may not be enforced by the court. So be aware of what the jurisprudence is in your particular jurisdiction before going ahead and putting in a prevailing party provision to make sure that it does indeed do what you intended to do and that it will be enforceable in your courts, in your jurisdiction. The guidance that we provide here is obviously general in nature. You would have to be able to adapt it to your particular jurisdiction and make sure that it is enforceable. In this case, you need to be very clear about what your intent is and make sure that the language that you use is indeed enforceable as a prevailing party provision in your jurisdiction. The other thing that I've seen with design firms is that you, as a design firm, may well have a prevailing party provision only in the case of a fee dispute, so that if you sue the owner for a fee dispute and you prevail, then you're also entitled to recover for your attorney costs and your collection costs, but leave the other areas as they are, so that if there's a negligence claim, then each party is responsible for their attorney fees. That may well be an acceptable provision. It may well scratch both sides of the equation, where if you are trying to recover your fees that haven't been paid, you're not paying for your own attorney fees. But if you had a negligence-based claim, then each party pays their own attorney fees. Be aware, however, that both parties have to be put on notice, generally, that this is a fee-shifting provision, and that vague terms such as costs generally are insufficient. So if you want to be able to recover your attorney fees, you have to specifically say exactly what those costs entail and lay it out. Is it collection fees? Is it court fees? Is it your attorney fees? All of those issues would probably have to be very specific so that both parties are on notice about what is intended. Some states require that a prevailing party provision be mutual, so that if there's a prevailing party clause for favoring one party, the states may well have a policy or a case law that states that if there's any fee-shifting provision like that, it's going to be reciprocal regardless of what the contract says. If you're in one of those states, you need to be aware of that. Again, this is something that you would have to delve into specifically into your state law cases and make a determination whether it makes sense to have just a one-sided prevailing party provision. So these are some of the considerations that would have to be thought about and considered in consultation with your attorney if you decide to have a prevailing party provision in your contract. Other things that courts have often looked at is, who is the prevailing party? Which party is the prevailing party? And generally, it really can be complicated because construction-related cases are very complex. There could be numerous cases where causes of action where you may prevail on some and lose on others, and it could be that it's a mixed result. So how is the dispute resolved? If there's relief awarded or judgment ended on your behalf and it's clear-cut, then you may be the prevailing party. If you settle, it could be difficult because the terms of the settlement may well involve you being responsible for certain parts while the owner is responsible for certain parts. So determining who the prevailing party is could be a significant part that needs to be resolved. In some cases, we've seen cases where you may only win nominal damages. Indeed, the other party may be responsible, and let's say they're responsible for, say, $10 of damages. But if you are still prevailing in that sense, you may still be entitled to your attorney fees. So those are some of the considerations that that the courts would look at. If you win, does it matter that you only won a nominal amount? If the case is voluntarily dismissed or dismissed without prejudice, you're generally not recognized as a prevailing party. Most courts would say, well, these parties have decided just to walk away, and so there's no prevailing party. The other thing that is out there in the courts is to determine who the prevailing party is a catalyst theory, where a lawsuit results in relief other than a judgment, such as a settlement, and if the plaintiff can demonstrate that it achieved the goal of the litigation by succeeding on a significant issue, and it brought you some of the benefits sought in the lawsuit, and there's a causal link between the lawsuit and the results, and you would have a stronger case to say that indeed I'm the prevailing party, I'm entitled to recover my attorney fees. So again, the prevailing party issue, while it helps guide folks about who's responsible for what, if it is actually litigated, that in and of itself could be a major point of contention between the parties as to what extent one party is prevailing and should be entitled to attorney fees. Nothing is simple if actually the provision goes through courts and is litigated in the court. And as you know, in construction cases, it is common for opposing parties to have multiple claims asserted against each other. At the end of the day, if both parties win on some claims but lose on others, the court must determine the prevailing party. So those are some of the issues that should be considering. So who nets the greater recovery oftentimes is the discussion point if you have multiple claims. So from your standpoint, you need to be aware of your state's statutory and common law requirements or restrictions on shifting attorney fees. So if this is something that you're actively considering, just be aware of what those requirements are, consult with an attorney, get very specific jurisdiction-specific advice before you go down this route. And ultimately, you have to decide whether the benefit of discouraging future lawsuits outweighs the potential risk that you may have of paying attorney's fees if you lose that lawsuit with your client. And that, again, is really beyond the coverage of your professional liability policy, but most firms, as part of their risk philosophy, need to have a position on how to deal with prevailing party provisions. All right. The next thing that I want to talk about are statutes of limitations provisions. And a statute of limitation gives the party who's been injured a certain amount of time to bring a claim against the defendant, right? So oftentimes if it's a slip and fall case, for example, from the time of injury, from the time that you were hurt, you may have, let's say, a year or two to bring a claim against the property owner who you allege is responsible for that. In the absence of an agreement between you and your client, courts generally apply the discovery rule, meaning a plaintiff may bring a cause of action within a certain amount of time after the plaintiff knew or reasonably should have known of the act giving rise to the cause of action. Now, you have to realize that the statute of limitations can have a significant impact on litigation between a design professional and owner. Although, something as simple as the slip and fall provides date known, you slip and fell on that particular date, so it's fairly easy to decide when the statute of limitations starts ticking. The accrual date for damages arising from a latent defect in design and construction is a gray area. When did the owner actually become aware that this defect is affecting the facility? When is that date determined? Is it earlier in the occupancy of the project or is it later? That could be a gray area. So a contractual provision defining the actual date for causes of action serves a valuable purpose for both parties, knowing when the clock starts ticking. And for design contracts, most of the time, if this is addressed, the date that you use is the date of substantial completion. And the reason is you generally know when the date of substantial completion is. It eliminates that discovery rule, because you've set it by contract. You're not saying when the plaintiff discovered the injury, you're saying, hey, upon the date of substantial completion for this particular project, that's when the statute of limitations starts running. So the plaintiff must sue within a certain amount of time, or after plaintiff knew or reasonably should have known of the act giving rise to cause of action. That goes away. That's the discovery rule. So substantial completion gives you a date certain for you as a design firm, knowing that from that point on, the clock starts ticking. If that is indeed in your contract, that is very protective of your interest. And looking at, both the AIA standard contract and the EJCDC documents have this type of provision. At least the AIA used to have it, the EJCDC still has it. All causes of action arising under this agreement shall be deemed to have accrued, and all statutory periods of limitation shall commence no later than the date of substantial completion. This is very protective of you as a design firm, because you know that after a certain amount of time after substantial completion, the ability of the client to come after you is limited. And this provides you with great uncertainty because if that statute of limitation has run out, you can oftentimes get the claim dismissed against you with a motion of summary judgment by saying, hey, the statute of limitations has expired, all claims against me are barred because it has occurred. Now, obviously, even if you have the contract saying that the limitation starts running at substantial completion, it's difficult. There are still issues that need to be resolved in a dispute. When does substantial completion occur? This is a term of art, and it may not always be easy to achieve or define. The contract often does define, has a definition for substantial completion. Oftentimes, it's defined in the contract as to the point where, in the opinion of the design firm, the work is sufficiently complete in accordance with the construction contract documents so that the project can be utilized for the purposes for which it is intended. As you can imagine, opinions may well differ about when that date of substantial completion actually occurred, especially if there's a dispute that's determined on when that date is. Also, you should realize, depending on your state, that some states may well bar any shortening of the statute of limitations. So if that's the case, you need to be aware of exactly what your state limitations are so that you can know exactly to what extent you've been able to limit that risk. And in other states, they only prohibit what they call an unreasonable shortening. And that really, I think, is just a case-by-case determination. The other thing that you need to realize is which statute of limitations applies. Is it a tort-based claim or a contract-based claim? You should know that states generally have shorter limitations periods for personal injury and negligence causes of action, and longer limitation periods for contractual and construction causes of action. So if the owner fails to file a lawsuit against you within the time period for professional negligence, you may well see the same claim against you, alleging that it arises from a breach of contract. So again, in most of these cases, it really does depend. There's no magic bullet, but these are the types of provisions that can certainly improve your risk profile if you have it in your contract. So those are some of the dispute resolution provisions that matter, that may well go beyond professional liability coverage considerations that could impact the risk profile of your project. The next issue that I want to talk about is really risk management in terms of a waiver of consequential damages provisions. It can be a very significant issue. It often comes up when we review contracts. And generally, you need to be aware of what the consequences are. In other programs, we've talked about limiting liability, a limitation of liability, saying that you won't be responsible for damages that go beyond a certain amount or beyond what is available by your insurance policy. This talks directly to the type of damages that you will be responsible for. Generally speaking, the direct damages are losses that arise directly from an injurious act, and we'll talk about, we'll illustrate this by comparing it to what consequential damages that are losses that do not flow directly and immediately from an injurious act. Okay. So if you, for example, are a structural engineer and you do not specify the correct steel for a structure and the structure fails, the cost to replace the defective steel is a direct damage arising from your failure to specify the correct steel. So that's a direct damage that the client suffers because we need to replace that steel that didn't meet the requirements for the project. So that's, by way of example, that's a direct damage, right? By contrasting that with consequential damages, these are the damages that do not flow directly and immediately from that injurious act, right? But they result indirectly from the act. So if we extend that example where the structural steel fails in the structural designer's solution, the owner's loss of use of the structure while the repairs are being made is consequential damage arising from your negligence, from your inability to specify the correct steel, but the damage is coming from loss of use. It doesn't come immediately, and it's a consequential damage. So the question often becomes, well, is that consequential damage foreseeable? Is it foreseeable that those types of damages would arise if you fail to meet your duty as prescribed by contract? And generally speaking, we won't get into that. There are two tests that the courts, in looking at the 50 states, use to determine foreseeability. In the first test used by a few courts, consequential damages are awarded if the courts determine that you assume the risk of the consequence in question, whether expressly saying that it's a court's determination whether it is indeed foreseeable. So most case tests, however, say that consequential damages are awarded if they are reasonably foreseeable. So obviously, there's a great deal of room for interpretation and argument if the concept is foreseeability. Because what is foreseeable? Is it foreseeable that you should be responsible for lost profits if the facility fails to open on time, and some of the cause is your negligence in the performance of professional services? That is indeed a case-by-case determination that may expose you to higher risk. So you can have two types of provisions in your contract to address consequential damages and the potentially very high damages that could result from that. You can have a general consequential waiver of consequential damages, whereby both parties agree to waive any consequential damages that may arise. Or if you have a very specific case, you can actually identify the types of consequential damages that could arise during or after the project. And we'll look at examples of both a general and a specific waiver of consequential damages. This is in the EJCDC documents. This is a mutual waiver, so if the court scrutinizes it, you'd be able to say, hey, both parties agreed to waive consequential damages against the other. And this is general, right? You are saying that we waive all claims against us against each other for special, incidental, indirect, or consequential damages arising out of or resulting from or in any way related to this agreement or the project from any cause or causes. This is generally held to be enforceable, but again, you would have to be look to your state's jurisprudence to determine exactly what kind of guidance they have put out there to determine the nature of consequential damages in their prior case law. If you have a very specific concern related to your client, you can have a specific provision that addresses those concerns. This comes from an engineering contract that is related to it's an electric utility, and it goes on to exactly spell out what those provisions are that are agreed that are consequential. Consequential. It specifically says these types of losses are waived. Loss of full or partial use of any equipment or facility, cost of replacement power or other utility services, cost of capital, loss of goodwill, claims of ratepayers, taxpayers or customers. This is a very specific provision that is obviously tailored to that particular project. And if you have very specific concerns like that, it certainly makes sense to try and negotiate one of these waivers into your agreement that is very specific. Now, obviously, you may not get what you want, but if the client doesn't want to give you a general waiver, you could say, hey, how about we waive consequential damages that are covered by that are not covered by design professionals insurance. So this way, you at least know that you have insurance coverage for consequential damages. So generally speaking, they are enforceable unless courts find them unconscionable for some reason. And the courts between two parties, between the design firm and an owner, they generally find that indeed both parties were sophisticated and there's clear intent to accept the risk, and they generally consider it as part of that bargain for exchange that we talked about at the beginning. If you're promising to provide services and they're promising to pay you, and this is an element of that bargain for exchange, courts will generally enforce a waiver of consequential damages. So the last area that I want to talk about are your business interests, both in terms of running your business and your ownership of documents. The first area that I want to talk about are confidentiality provisions that the owner may well have in regards to their project. They're going to be sharing a lot of information with you. If they consider that information confidential, they certainly want to make sure that that information doesn't leak out, that what is proprietary to them stays proprietary. The other thing that we'll talk about is the ownership of the instruments of service that you provide to your client. Some clients want to own everything that you produce. That is both financial concern to you and also a liability concern that we'll talk about if those documents are used for other projects. But the ownership provision to who owns those documents is certainly a very important part that needs to be addressed in your agreement. This could be a very important issue to an owner. And if they want to maintain things as confidential, you need to be very concerned about the scope and duration of any confidentiality provision. Ultimately, you want to be able to define and limit the universe of documents or information to which the provision applies. And ultimately, there should be, ideally, a time limitation on the survival of the confidentiality agreement. The first thing that you need to look at is defining what is confidential. There should be a term in your agreement that says what is considered confidential. And this is a fairly common clause that you find if it's in the public domain, was previously known to another party, it's independently developed by the other party, or you get it from somewhere else, this is not considered confidential information. You don't want to agree to a confidentiality clause that is too broad in scope and duration. And it should never prevent you from complying with legal or ethical obligations. You may have to disclose, for example, certain information if it's required by state licensing laws or environmental laws or regulations, depending on the scope of services you're providing. You may have a duty to report a potential violation of law in your as a licensed professional. So the contract should always list those types of issues that you are indeed a licensed professional who has duties that are not going to be restricted by your confidentiality agreement. And this is the type of clause that you want. You want a time-limited clause. And obviously, from a business standpoint, you want to make sure that your employees know about your confidentiality provisions that apply to them that you've agreed to with your clients, so that the information doesn't leak. And as I said earlier, if it's required by a legal proceeding or law, you will the confidentiality provision does not extend to those issues. Oftentimes, however, you are required to give written notice to your client about your notification obligation. So again, I can't stress enough that it should not prohibit you complying with your legal or ethical obligations. And one thing that I have found is that you want to ask the client what is exactly confidential, because oftentimes in large projects, there's a lot of information that flows your way, and requiring that the client specifically say what is considered confidential will help you make sure that those issues, those matters that are indeed confidential are handled appropriately. If everything is confidential, then it can be a very huge burden on your operation. So depending on what the provisions say, you may have to keep records of all the copies that are made, when the copies were made, who made the copies, who received the copies. This can be a very burdensome obligation, especially if it's a large project. So you need to account for any additional costs that may well be imposed on you because of your confidentiality provisions that the client has imposed on you. You should also be aware of what it is that you're supposed to do with this, especially once the project is done. Are you expected to required to return them or destroy them, and how is that documented? You should always retain records that are necessary for your own business, and of course retain any work product that is created during the project. One thing that we're seeing increasingly is separate confidentiality agreements, and these are indeed no different from any other contract that you have, but they may well have other clauses that impose additional obligations on you, and these would need to be evaluated on their own merit. But always make sure that you review the services agreement and that there isn't a conflict with what is agreed to in the services agreement, so that there's no ambiguity about what your responsibilities are. So that is really, again, a business risk, not necessarily a professional liability exposure. You do have a common law duty to keep your client's information confidential, but the contractual agreements may well provide additional duties that may impose additional obligations on you that you need to account for in order to make sure that it isn't a burdensome obligation. The last thing that I want to talk about are the ownership of your documents. There's the documents that you produce for your clients as instruments of service. So oftentimes these are the construction documents that are provided to your client in order for them to construct a facility or renovate a facility. There's two separate and distinct issues that need to be addressed. Who owns the rights to the drawings, specifications, and other documents? So that's physical ownership of the drawings and the rights to them. And who has the right to reproduce the work? That would mean the copyright. Oftentimes what you provide to the client is actually a license to use the drawings, and you retain both ownership and copyright. And that's certainly what is contemplated in the standard form document. You have really both a financial interest in the use and reproduction of the work and also a liability concern. If the owner has the right to use the drawings and it's not restricted in any way, you lose the opportunity to earn fees for the use of those documents for other projects. If the client has that and you don't have any rights to them, there may be an opportunity for you to charge fees for the reuse of those drawings, and so that's a loss of revenue opportunity. The liability concern is that if they use it in a new place and something doesn't work, you may still be held responsible or may face a claim if there isn't a clear provision saying that any subsequent reuse is at the owner's sole risk and they agree to indemnify you for that. So you have two issues that you want to address when it comes to the ownership of the documents that you produce. The industry standard is that, as I said, you retain ownership of the plans, specifications, and other work products that you prepare. And the common problem is that the owner wants to use the drawings subsequently years later and engage a different design professional. And so that's an issue that the owner wants to resolve, and you want to make sure that your interests are protected if they want somebody else to do work on the project subsequent to completion. Generally, there must be small allowances for an owner to use or reuse designs, but it may subsequently alter or destroy your copyright protections because essentially they've been allowed to repurpose the drawings that you provided. The key element for design firms is to make sure that you retain rights to design elements that predate the project in question, so that standard details and things that are that you spent developing are not transferred over to the owner. This is fairly well discussed in the standard form documents. I've included the language here to make sure that you're aware of what the standard form documents say as you negotiate with your clients. Ideally, what you want to give them is the right to use, the license to use the document for a particular project. And if they do go ahead and use them for something else, then that is indeed at their own risk. Of course, this protection is only as good as your owner's ability to protect you, but at the end of the day, they have put the owner on notice and any subsequent users that that rely on that transfer of documents. So these are some of the issues that may well go beyond the professional liability policy. We've covered those topics in other programs, but as a firm negotiating with your clients, you need to be aware of what some of these other provisions are. There's a lot of provisions that need to be addressed, and really what we've discussed today are only a few of the many that may have a significant financial impact. Ideally, you want to reduce your risk by shifting risk to other parties or insurance. The goal is to discourage or reduce the potential for litigation, and of course, protect your proprietary interests. But at the end of the day, I think one thing for you to take away is that there's no magic bullet, and as you evaluate your projects and your clients, you need to evaluate the potential advantages and disadvantages of these particular provisions, and whether they're included or not, depending really on the nature and type of the project, and ultimately, what is your current risk philosophy? Does it work for you? Are you comfortable taking on these risks? Do you have a sufficient understanding of what your exposures are? And this webinar is really intended to provide you with some guidance along those lines so that you have an understanding of what your other exposures are beyond just the coverage of the professional liability policy. For more information, and that brings us to the end, I will look for any questions that have come in, and we'll respond individually. We are at the end of our program. For more information, we urge you to visit our website. We've got a fairly new website, and if you've not already established an account, you should do so. I urge you to register, get an account, go through our account, go through our website, review claim studies, practice management information, contract language, commentary, and there's also, of course, past webinars, and much, much more. So please, if you haven't had the chance to go through that, I urge you to visit our website. I thank you for participating today and look for that email survey with information on how you obtain continuing education credits. And if you have any questions, contact Andrea Tiger at our office. This ends our webinar today.